Me, please, my lord.
Yes.
Well, I beg to mention item number 9. Yeah, my lord, we have been recently engaged by the petitioner, my lord, so we're taking some time to go through the report.
You've been engaged by the petitioner.
My lord,
What about Mr. Paul?
we have already received consent from the others.
Huh?
We'll be taking.
We've taken consent from him. He'll be there also in the case, but I'll be leading.
Okay. So, what is your prayer?
Lord, praying for adjournment today, my lord.
How long?
2 weeks.
2 weeks, my lord.
On prayer made by the legal counsel for the petitioner. This is matter to 2 weeks.
Please, Your Lordship. Lordship, I beg to mention item 3, my lord, on behalf of respondent 3 and 4. Really, my lord, I could not prepare because of the appeal that is listed today. I'm praying for next week, my lord.
But this is a whole matter.
Next week, Monday always.
Your lordship, kindly 2 weeks, if not taken up today, lordship.
2 weeks.
2 weeks, your lordship. And one, your lordship, if I may just inform your lordship that respondent number 4, your respondent number 3 is not contesting the matter. The 4 respondents, respondent 1 and 2 is the Zarul's Autonomous District Council.
Or 3 is
3 and
that
4 are private respondents. However, 3 is not contesting the matter. They have not filed affidavit, nothing. He's for 4.
you are for 4. Or you are for or JGDC. On prayer made by the parties. This is matter to 2 weeks.
Highly obliged, Lordship. Lordship, I have a similar request for item 5, my lord. On behalf of respondent number 3, my lord.
And to the petitioner, Lordship.
Next week, my lord.
On prayer made by the respondent. This is matter to 1 week.
Highly obliged, Lordship.
May it please your Lordship. Lordship, I beg to make a mention of item number 4, Lordship.
This is a 2020 matter.
Lordship, I'm praying if this matter may be listed after a week.
This involves appointment.
Yes,
Lordship, she's challenging the petitioner herein is challenging the selection process, Lordship.
Selection process. So, what happened to the selection process?
Lordship,
Stalled or
Lordship, prior to pursuant to the recalling of the select list where the candidate had appeared successful, Lordship, MPSC, the Commission, had made it mandatory for written examinations to be to any of the posts which we advertise for, Lordship. Prior to this,
across
it
the
was
board.
Lordship.
So this is included.
Lordship.
And the process herein is included,
Lordship.
for which the petitioner is called upon to appear,
Lordship.
and you have resisted.
Yes, Your Lordship. Your Lordship, initially there was a selection process. I have participated in the selection process where it involves just a personal interview, Your Lordship.
Yes.
So I've taken part in the personal interview and I was selected, and my name came out as serial number 2, Your Lordship. Now, pursuant to this, Your Lordship, there was a allegation that there was some nepotism. So inquiry was done, and there was no such case of nepotism, Your Lordship. And then the MPSC respondent, Your Lordship, they had kept the selected list on abeyance and had issued a notification saying that written examination is compulsory, Your Lordship. That is the case, Your Lordship. We are challenging the written examination part, Your Lordship.
So that notification is impugned.
Lordship. The entire selection process, Lordship.
Even so, you see, by now you would have missed out if at all you are qualified. You would have missed out on the number of years. 4 years have passed by, almost 3 years plus. We'll try to speed up this matter. How long?
Lordship, 1 week.
Next time be sure to
Lordship.
on prayer made by the respondent, MPSC. This is matter after, or not objected to by the petitioner. This is matter after 1 week.
Highly obliged, Your Lordship.
Lordship, I'm praying for a similar prayer in item number 6, Lordship.
In this rate, I will not have any matter today.
Lordship, I have an objection to it. Lordship recalls last week also this matter was listed. They are enjoying a stay on the proceedings in MHRC for the last 1.5 years.
Okay. Or that
So it was decided that today matter will be taken
Power
up
of
for
the-
hearing. Lordship.
power of the Human Rights Commission.
Lordship.
Lordship, I'm praying if this matter may be listed tomorrow. We've been unable to prepare the matter, Lordship.
Lordship sees this is what is going on, Lordship, for the last 4-5 days, 6 days. We have exchanged our pleadings. It's been over 7 months. On the last date also a similar prayer was made and Lordship was adamant that on the next date it will be taken up for hearing. That is why a short date was fixed.
You are for?
I'm for MHRC, Lordship.
Okay. You
Lordship,
are,
I'm for the petitioner in this matter.
it's their case.
Lordship, my proceedings
Okay,
are
your
state.
proceeding. State. It was state.
Lordship. Since 2021.
On prayer made by the petitioner. This is matter tomorrow.
Highly obliged, Lordship.
Obliged, Lordship.
Supplement cost list, item number 1.
May I please, Lordship? It is 439 bail application for granting bail to the accused Sri Suranjan Mato and Babulu Singh in connection with the Clarier Police Station, case number
Is this
20 by
appearing
3/23, Lordship.
Good outside. Good. Can we have a copy of the petition also? Still has not been served?
Already, sir.
Huh?
Already, sir. There is one copy already given. Lordship, we have been arrested on 14 March 2023.
Mr. Sulai, you have not given.
Lordship, the brief is not there, Your Lordship. Let the matter come tomorrow, Your Lordship. Let it come tomorrow.
I don't think you're. It's not a local here.
Already been served notice.
You don't have extra copies, do you?
Let him make a submission, Your Lordship. I
Okay,
believe,
I will
I
give
believe
you.
it is a such case. If required, then we'll have instruction in the matter, Your Lordship.
Yes, see, if it is a statutory case, then what is the stage of the case?
Lordship,
What is the stage of the case?
we have been arrested on 14 March 2023, Lordship.
Okay, I've gone through the papers. The case has been charged sheeted.
Right.
So it must have been, at the stage of consideration of charge or evidence or, what is the stage?
In appearance stage, Lordship.
Appearance.
Lordship. The rejection order, page 29, Lordship.
We're not talking about the bail. I'm talking about the stage of the case. If you say appearance means it's for consideration of charge,
Right.
most probably.
Lordship,
Investigation is over.
170 days I am behind the bar, Lordship.
It doesn't matter.
I think it's
Maybe
mostly it must be a commercial quantity, Your Lordship.
Lordship, 72 kgs.
Or 72 kgs. Then we'll have instruction, Your Lordship. Let it,
so when?
Lordship, let it come after 2 weeks.
Wait 2 weeks,
We need after 10 days, Your Lordship.
10 days.
10 days, Your Lordship.
180 will complete.
You want to suggest a date? You suggest a date.
Lordship,
You want to suggest a date?
okay, you can.
Heard, Mr. You are Mr.
PK Das.
P.K. Das, Learned Counsel for the Petitioners. Also heard Mr. N.D. Shulai, Learned AAG, appearing for the state respondent. This is an application for grant of bail under section 439 CRPC. The red AG has submitted that the concerned case is at this is at the stage of consideration of charges since charge sheet has already been filed. It is therefore submitted that the relevant records may be called for and specific instructions may be allowed to be placed before this court on the next date fixed. So we don't know when is the next date.
Lordship will furnish the copy, the xerox copies of the case diary, Lordship. So far, the case record from the trial court, my humble and respectful submission may not be called, Your Lordship. Otherwise, it will amount to halting the proceeding.
That's what that is why I want to avoid them.
Lordship. So we'll produce the case diary, Your Lordship. The xerox copies of the case diary.
Yeah, I know. Therefore, it is submitted that the copy of the case diary,
Lordship,
including the charge sheet, may be allowed to be filed for this court. On premium, the same is allowed. List this matter on 11th.
Let it be on 13, Your Lordship.
13, Mr. Das.
13.
Okay. This is matter on 13th.
Lordship. Oblige, Your Lordship.
13th September.
Yes.
Oblige.
Item number 2.
May I please, Your Lordship? My Lord, this is application under section 438, my Lord. Praying for my Lord's protection from being arrested, my Lord. In connection it...
Yes, who's for the
public
prosecution?
We have in fact served the copy. We have served the copy in the office yesterday.
Something wrong with the office. Let him make a submission, Your Lordship. After then I can.
My Lord. So, my Lord, the charges, the allegations against me, my Lord, when we read the FIR, my Lord, it will go to show that actually there is nothing against me, but the charges that has been brought against me is section 315, my Lord. And section 315 is very grievous, my Lord. This talks about an act done with intent to prevent child being born alive. And the punishment, my Lord, that would extend to 10 years, my Lord. Now 10 years, my Lord. So therefore, my Lord, I can be arrested anytime, my Lord, because section 41A is not required to be issued here because it's more than 10 years, my Lord. So, my Lord, now the accusation, my Lord, the accusation against me prima facie shows that it does not stem out for ends of justice. But, my Lord, it has been filed with ulterior motives, my Lord, to get me arrested, to injure and humiliate me. That is the only motive behind, my Lord. The allegation is as such that, my Lord, the complainant, who claimed herself to be having an affair with me, my Lord, she says that she got pregnant. And then because there was a decision between me and her to abort the child, my Lord. Now the complainant, she is not a minor, my Lord. She already have a 7-year-old child, my Lord. As she's a single mother, she is already having a 7-year-old child. She is a 35 plus lady, my Lord. And then thereafter, she says that I stopped communicating her for 2 weeks. And then I have sent a medicine, which she said she took the medicine and it did not work. Probably she is saying that it's an abortion pill. And thereafter, she asks some more from my driver, which I sent. And after taking that medicine, my Lord, she started having pain and that is where she lost the child. This is the allegation against me, my lord.
So your complicity is established there.
My lord, that is only the allegation against me, my lord. That's why I have said, my lord. Now, why did I say that, my lord? She only wants me to get arrested for reason best known to her, my lord. That will come, my lord. That will come, and I'll just show, my lord, few of the when I've blocked her, few of the status that she has posted in her WhatsApp, my lord. It is from page 26, my lord. My lord may kindly have a look at this just for the purpose of interim protection for now, my lord. My lord may call for the CD. What's that? She says that she warns, don't ever try to mess with me. I'll go direct to mass and media. My lord, now I'll just say my credentials, my lord. I'm a politician, my lord. I'm a politician, I'm a businessman, I'm a contractor, my lord. I have a good reputation in the society, my lord. And not even, there is not, in the past, not even one case I have been, any case has been filed against me. My credentials are very clean, my lord. So this is one. Second,
It's just an affair gone wrong.
just an affair gone wrong. And why it has gone wrong also, my lord, kindly, next one, she's saying this. Next paragraph 27, sir. You want to start a contract? Let's see if you can. It's my turn to play a game. That is, and then now, my lord, when FIR was filed, I have participated initially under the protection, interim protection. I've spelled out everything. Now she went to the SP and she was able to convince the SP to replace the IO. Now she's saying in next part 28, yeah, finally I'm replacing my IO. This person is useless. Useless because the IO is not arresting me. The only thing she wants is to get me arrested. Page 28, madam. Page 28. And my lord, now the next she started threatening when the police is not doing anything. Page 29. Dear friends, kindly check the Shillong Times tomorrow. Something's gonna pop up. So that is why I said, my lord, this FIR has been filed. It's not been stemmed out purely for something like I have done such a heinous crime that I should be arrested and I should be interrogated, my lord. This, in fact, this has been falsely implicated, my lord. This is a case where I have been falsely implicated, my lord. And my lord, kindly look at the next page 30 onwards. This is the lady who has been texting my wife. She is saying, cause he doesn't leave me, I need only medicine, ask him. She is asking my wife to ask him to send medicine. And here she is admitting that I'm denying to give the medicine. So, my lord, so now, my lord, I must say that, my lord, she said that there's having an affair, my lord, even if that is admitted to be true, my lord. That's not a crime, my lord. So, my lord, at this juncture, my lord may call for the CD, my lord, and I would pray, my lord, for an interim protection, because 315, my lord, it's 315, my lord, it's quite a serious in nature, my lord, and I can be arrested any moment, my lord. And if that happened, my lord, then we will greatly prejudiced.
Lordship, can you come to page 15 is the FIR, Your Lordship. The type copy appear at page 17.
Go for this one.
Lordship, if I may read it, Your Lordship.
Yes.
I'll read, Lordship, towards the bottom, Your Lordship, somewhere 1, 2, 3, 4, 5, 6, 7, 8, 9. Lordship, from the bottom, the line as I started bleeding and peeing. Lordship, got it?
Yes.
Lordship, what did she say? But it didn't work. I informed his friend it's not working, so he bought. He That means the bail applicant herein. He bought me another medicine and I took it. On 25th July and 27th July, after drinking the medicine, I started feeling pain and pain. So today, I went to consult with the doctor of Nasser, told me without any concern why I took medicine and why give you the medicine without any so. And the doctor said to call him, bring him, and I cannot contact him. So I informed his friend to tell him to come to hostel, but he did not come. Even my friend tried to contact, but they did not talk to him. Therefore, I request you to kindly take and so, Your Lordship.
For cheating me.
So, Lordship, if this is the case, Your Lordship, it appears, Your Lordship, that a baby is there, Your Lordship. So, if that medicine is given, Your Lordship, by the petitioner, in my humble and respectful, that will amount to murder, Your Lordship.
Assuming without admitting, my
murder
lord.
of an unborn child, Your Lordship.
Assuming without admitting, my lord, is there an allegation that I force her? She's a 35-year-old lady plus. Is an allegation that I force her? Is it an allegation that I gave her a medicine saying that this is a headache medicine or something medicine?
Lordship, specifically in the FIR, she said,
That is her allegation.
I took the medicine.
I took
then
the
it
medicine.
started to
Voluntarily, I took the medicine.
So,
Let's have a look at the CD then.
My lord. Till then, my lord, kindly protect me.
Lordship,
interim,
in
my
my
lord.
humble and respectful submission, interim protection in this kind of case, Your Lordship, it's not called for, Your Lordship. Then it may.
Anyway, the court will look into it.
My lordship, my lord.
Since the applicant has come,
My lord.
when there's an
Apprehension.
an apprehension,
Yes, my lord.
Lordship, that is true. Because he has come, there is a reasonable apprehension. But the fact, Lordship will kindly see the FIR, Your Lordship. Kindly see the FIR, Your Lordship. The allegation made in the FIR, Your Lordship.
that is true. Let's see what the IO
My
says about
lord.
it.
My lord. My lord.
So you produce the case diary.
My lord.
When?
This is Shillong.
Shalom. Madanati.
Then, Lordship, today is.
Today is 30th, sir. 30th September.
Do it by
6th September. Sir.
6.
1 week.
Yes, Lordship, by 6 will do.
My lord.
Heard Mr. Yobin, counsel for the petitioner. Also heard Mr. Andy Shulai, learned EAG, appearing for the state respondent. In this kind of cases, is the complainant required to?
Most of she has to be.
My lord.
She has to be heard, Your Lordship.
There is a provision for that. For the
Complainant, we have of course not met her party because they.
no, is it required for her to be heard? Her or whoever is the complainant?
My lord, then I will make her.
No, if it is required, if it is necessary, otherwise it's a prosecution's case.
My lord.
Usually, you see, some
She may have a say, Your Lordship.
she may have a say, or some people may not want to be exposed.
My lord.
Going by that judgment of Ashish Mishra, Your Lordship, then yes. At every stage of the proceeding, the informant is required to be heard.
You have a citation of that?
Lordship, right now I don't have, Your Lordship. That Lordship will kindly recall that running over of those agitating farmers.
Oh,
that is the case. He was arrested. He was this. He's the son of the Union Home Minister. Union Minister, Your Lordship. He was arrested. Then then went to Sumkut for bail. No, Your Lordship.
My lord, with the Lord's permissions, that I can add in the site, my lord. By this thing, I'll take steps today itself, my lord. The third one I can give Lord's permission.
That will not be. Court will give you leave.
My lord.
To implead the complainant.
My lord.
You take steps.
My lord. How obliged.
Kunung to The petitioner has approached this court with an application under section 438 seeking grant of pre-arrest bail in connection with
Madanti PS case number
80
/7 of 2023
under section 31
315 ICC.
Being named in the said FIR, therefore the petitioner has asserted that there is reasonable apprehension of his being arrested at any point of time. Hence this petition. Though the learned AG has pointed out that there is no, that the petitioner has no case, inasmuch as the allegation made in the FIR are serious in nature. Therefore, even at this stage, the prayer made by the prosecution is for this application to be dismissed at the outset. This court has considered the submission made and has gone through the petition without properly looking into the details of the matter, including the process and progress of investigation made thereto. This court at this juncture would not be, is not inclined to dispose of this petition at this stage. The prosecution is therefore directed to produce the CD or copy of the CD on the next date fix with the latest status report of investigation. The petitioner, as submitted, is also directed to plead the informant, the complainant, as party respondent herein. The petitioner, on the petitioner on prayer made for impleadment of the complainant herein, the same is allowed. Accordingly, registry is directed to correct the cause title. The petitioner is also directed to take steps on the newly pleaded respondent. The matter will now appear on the next date fix. When did we say?
Lordship on 6.
You think service will be maybe will be affected?
May
by
not
that?
be possible, my lord, to the private respondent, my lord, by then. I will take steps today itself.
Personal service will do, Your Lordship.
You can do personal service.
Dusty service, I can try, my lord, dusty service.
How to pour atau ka service ni even through dusty. As prayed for, list this matter on
6.
At least the interim protection, my lord, otherwise get arrested and
in the meantime,
yes.
as prayed for, interim protection is given to the petitioner in as much as no coercive action should be taken against him. He is, however, directed to appear before the IO as and when required, and that he shall not abscond or tamper with the evidence and witnesses. He is also directed not to meet or contact the complainant personally.
My lord.
So,
Daily cost list item number 1.
My lord, in this case, I am for respondent number 5. I filed my counter as well as I filed the misapplication. I was seeking for modification of the status quo order passed by my lord on 21.
With the confusion has been prevailing in the area, I have assumed the charge on 19 regarding that acting chief. Now, my friend was suspended on 18. I assumed the charge on 19. I issued notice for the election of the office bearers and executive committee to assist the acting chief. And on 21, we also informed the district council that I have assumed the charge on 19 already. The Saturday and Sunday was holiday for district council. Now on 21, district council also appointed inquiry officer. Now I held a meeting on 23rd and office bearers were elected and we sent for approval. In the meantime, we also came to know that my lordship has passed the status quo order on 21, where we informed that we assumed the charge. Now on 23rd, the writ petitioner also issued a notice calling for public meeting. So because of that, my lord, confusion is going on. I assume the charge and he is still issuing the public notice. That affects the, my lord, the public, as well as, my lord, my administration. So I sought for some clarification of that status quo order. That is the application I sent copy to my friend yesterday also. And it is part of the record. It is already
received the copies last night only. So I need to file a reply to this case. And especially the affidavit which my learned friend has filed in the entire case in the writ petition.
You have also filed your...
I filed in my counter in the entire writ petition also.
My lord, I am appearing for the district council here in this matter. My lord, on 21st August, the council has also appointed the magistrate in Mokurwan as the inquiry officer. I have a copy here. To inquire into the charges levelled against the petitioner. My lord, from the records, I have not filed my affidavit, I will need at least 2 days. From the records, it would indicate that the petitioner was suspended primarily on the ground that there was 15 crores which was released by the collector in respect of the land compensation in that area. Now, my lord, this case was pending because there was a dispute between Langrin Sameship and the mother of the petitioner. But the issue here, my lord, is that the petitioner, in his budget estimates for the year 2022-23, has not indicated this amount of 15 crores. In fact, he has said that this 15 crores, in other words, it does not belong to the HEMA. It belongs to some managing committee, which is incorrect, my lord. And in fact, your lordship will see the writ petition, in the writ petition itself, at page 104, very interestingly, my lord. This is the show cause filed to the executive committee, page 104.
Yes.
The last paragraph. The third point in paragraph 3 of the complaint relates to donation of 77 lakhs to a church where the undersigned and his family members are members. It is humbly submitted that the undersigned has made significant donation not just to a singular church but to all churches within Langrin Sameship. That is 37 churches in total, and such donation amounting to rupees 1 crore 48 lakhs. Apart from the aforesaid 37 churches within Langrin Sameship, another 73 lakhs was also donated to churches outside the HEMA. Therefore, the total donation amounts to 2 crores and 21 lakhs. Now, this is the money of the HEMA. Can the petitioner, as a CM, do however he pleases? This is a very serious allegation. Now, can he be allowed to resume charge of the office when on the face of it, there is misappropriation of funds? He doesn't want to give it to the people, but he is willing to give it to the churches, even the churches which are outside the Sameship. That's why
all these allegations are
yes,
subject matter of the inquiry.
Inquiry. That's what, my lord, the district council has just passed as appointed an inquiry officer.
No, that one. This is one.
No, but this is the.
Yes.
This was issued on 21st of August.
Okay.
Appointing one Iblian C. Lindo Monai, Magistrate First Class, to inquire into the charges. The only prayer from the district council is that let the inquiry
Mr.
proceed.
Nobi, yes, because see,
My-
this court will not go
Yes, into
the details of the the charges against you, or what is right, what is wrong. That would come in course of an inquiry. The matter will be clear. Prima facie, what the court would require is whether due procedure was followed. If it is so, then it is so. If it is not, there will be a course correction.
Your Lordship, may I submit? I am before Your Lordship regarding a complaint which was lodged by some busybody. Now, the grounds which I have taken in the petition, not on the merits of the complaint, but whether the statutory provisions provided under the Act, which was enacted by the District Council, that has been followed or not. Because when a statute provides something else, they cannot do something else. An Act has been framed to comply with, not to violate. Now, my basic challenge on the statutory provisions, whether they've been complied or not. Now, Your Lordship, if Your Lordship come to a conclusion that those statutory provisions have been violated, then where will, these are all consequences of that. Then all those inquiry will go, the impugn order will go. That is why I am before Your Lordship. Now, if Your Lordship comes otherwise, saying that, okay, it's not maintainable, you go and participate in inquiry, I'll go and inquire. But my grievances has to be looked into by this Honorable Court. Whether those statutory provisions have been complied or not. If it's not complied, how can they just bypass those provisions and call for an inquiry officer and suspend me? The manner in which I was suspended, Your Lordship, I've apprised the other day. On Saturday morning, they provided me with a notification saying that you've been suspended. I immediately rushed this court on Monday morning, challenging the notification. On that particular day, submission was made that there's an order. If an order is there, that order should be supplied along with the notification. Can you look at the malified and colorable exercise of the District Council in a manner which they have exercised, all with an oblique motive? Now, after writ petition was filed, to render my entire case infructuous, they have again come to my house and supplied me the suspension order. Now the suspension order, kindly look, Your Honor, Your Lordship is before Your Lordship. Recently there was a case which is similar to this case. This relates to Nongpo Sardarship. The Sardar was suspended. They did the same trick. They issued the impugn notification, and in the notification, which is different from this, that impugn notification states that due to the executive committee had taken a decision that by order dated so and so, whereby the Sardar of Nongpo has been suspended, you are hereby suspended, and then an acting has been appointed. But in this case, surprisingly, there is no order in the notification, which goes to show that that order has been, whatever has been done later after the impugn notification. That's besides the point. I would like to bring on affidavit the impugn order before this Honorable Court, and would like a reply to the miscase which my learned friend has filed, and the affidavit opposition, who is a beneficiary in this case, Your Lordship, has immediately filed an affidavit shielding the actions taken by the District Council. There are many things that I have to say in the affidavit. The status quo has not been misinterpreted. I have immediately approached this court, and this court has granted a status quo order. And a query was made on that particular date, show some evidence whether you have taken over or not. No. Because, I'll come to that also, because there's a violation to the statutory provision also. Because there is a manner in which how things have to be done, handing over and taking over. There was nothing as such. After the status quo granted by this court, Your Lordship, That is why we have never handed over, and we're continuing with the functioning as its aim. So that's why I would like to have a comprehensive affidavit. I would like to bring on record also the suspension order which the district council have supplied to
With
me.
regard to violation of the procedure, I looked into the procedure, the act and the rules. The stand taken by my friend is not supported by the rules. The rule is very clear. It is not required to supply the copy of the complaint to the executor part if the suspension is pending in the district council is enough. And since I have filed my application for modification, if my friend wants to give
What we can do is, we can decide this matter finally.
Yes, that's what I
Decide this matter finally, so that all the, you see, what happened is, once you go into this, ancillary matters, we get lost in the
Yes.
process. You have to first deal with one miscase, then another, and finally. So what this court would propose is, if the parties are willing, file their pleadings, file their affidavit, or and
The only thing is that number 6, my lord, has not been served, I think. There's respondent number 6.
Who's number 6?
They are the complainants.
Oh, they are the complainants.
Yes.
We've taken step will ensure that, because we have taken by Dusty service also. By Dusty also and by registered.
For which my friend did petition is to delay the matter.
We will file also.
No, I have no intention.
This court will pass this orders.
Yes.
If the parties are in agreement, we'll dispose of this matter at the earliest.
I do agree.
And as far as the status quo is concerned, it will remain. But until the next date.
Until the next day.
And if on the next date, it seems as if the matter is not going anywhere,
Then we'll
that
decide.
status quo will be vacated.
Very fair.
So we'll put it that way.
2 weeks, Lordship.
Fine, 2 weeks, good enough.
I'll give them an advance copy also.
Fix a date, suggest a date.
September 14, 13, 14, Your Lordship.
Any day.
Not on Friday.
Not on Friday. 14.
13.
13. Heard Mr. Pinawil, counsel for the petitioner, who has submitted that you have taken steps on respondent 6.
Yes. It's there in the office note, Your Lordship.
But not, service report has not come.
No, not yet.
My friend even did not serve a copy to us.
We supplied by hand also.
Did not submit to me.
The copy of the petition?
Copy of the petition means it did not supply to me. I managed from this council and filed my reply. So the intention of my friend is to delete the matter.
That is just to trap us. They didn't come and ask for a copy also.
It's incumbent upon you.
That's besides the merit of the case.
Read them as parties, you should have given them a copy.
That is why Lordship is, being a beneficiary, is trying to shield the district council, the actions done by them.
That is not effective. No. That the notice that the report on the notice issued upon the respondent 6 is yet to be confirmed as to whether the same has been received or not. However, at this point of time, the Learned Council would submit that fresh step may be allowed to be taken by Dusty, so as to ensure that the same is duly served. Mr. H.L. Navariso, Senior Counsel appearing for the respondent number 5, has in the meantime submitted that an application has been filed for this court seeking clarification on the status quo order passed by this court on 21/8/2023, to which Mr. Nombri, Learned Counsel for the petitioner, has submitted that he may be allowed to file a response to the same. Mr. T.T. Dingro, Learned Counsel for the you are special counsel?
Yes.
Special counsel for the respondent KHDC has submitted that counter affidavit may be allowed to be filed within the next date fix, since the same could not be filed today. Next. Looking into the facts and circumstances of this case, the parties are in agreement that the core issue may be taken up and decided at the earliest on the parties filing their respective pleadings. Next. Accordingly, as agreed to by the parties, this matter will be finally heard on the next date fix. In the meantime, respondents are directed to file the respective counter affidavit, and the petitioner, if so advised, may file the rejoinder to the same. To a counter affidavit with advance copy to the petitioner. As to the petition filed with the respondent 5, seeking clarification of this court's order dated 21/8/2023 as regard the status quo, this matter would not be decided today, but would be finally taken note of in the final hearing. Be that as it may, in view of the above direction, the petitioner is directed to be diligent in his pursuit as far as this case is concerned, and the issue of status quo will be relooked by this court on the next date fix. Anything else?
Lordship, permission. May it be fixed for admission stage.
Admission hearing.
Admission.
Atau kau atau hearing ni for admission hearing.
For admission hearing.
Yes.
2 weeks is good enough for.
It's enough. I think speedy.
Also, I'd like to bring on record the suspension order also, an additional affidavit.
Terus aku ikat pada the petitioner has also submitted that he may be allowed to bring on record certain documents, including the suspension order issued upon him by way of an additional affidavit, by way of an affidavit. To this, the respondent may also file their response if so advised. I wonder if it can be done. Everything can be done by 13th.
Then we'll go to 20th, Your Lordship.
We'll fix it on
Because there'll be rejoinders, there'll be.
Oh yes.
We'll try, my lord, on the 13th. We'll try.
We'll do that.
Your Lordship.
Much
Obliged.
Item number 2.
Well, Lord, in this case, Lordship permission, we have filed a petition affidavit, bring on record the constitution of the Masjid Committee. We serve a copy of the petition.
Oh, you are the managing committee?
We are for the managing committee, school managing committee. In the earlier occasion, Lordship allowed us to bring on record the constitution of the Masjid Committee. So we serve a copy to the Learning Council also. Take it out after a week.
There's no requirement for response to this.
Well, this is as per the contingent stating that in the constitution, there's nothing as such indicating that we are the sponsoring body. My lordship can fairly come to the affidavit.
Yes.
Filed by them, my lord. This said constitution, my lord, came into force in the year 2013. 2013. Now, this dispute has been set at rest in the year 2018 as per the inquiry conducted by the then respondent number 3, which came to a conclusion of finding that the Masjid committee is a sponsoring body. Now the contingent is stating that no. Now, my lord, I've already stated that I will not be furnishing any documents as I've already submitted that. Relevant papers have already been before this honorable court.
Yes, yes.
So we rely on those.
Who will hear this matter?
After a week or 2 weeks, subject to lordship convenient and my friend.
So when do we?
After a week, my lord.
After a week. Mr. Mitchell Sangrisu, Landed Senior Counsel, appearing for the respondent number
Madam, School Managing Committee.
Respondent number 4.
Respondent number 4, oblique School Managing Committee, has submitted that an affidavit, additional affidavit has been filed by the respondent number 4 to bring on record certain relevant documents, including the constitution of the copy of the constitution of the Garikhana Masjid Committee, Lumdingjeri, Shillong. The General Counsel for the petitioner has submitted that there is no requirement for filing of any rejoinder to the said affidavit. In view thereof, parties have agreed that this matter will be finally heard on the next date fixed. This is not after 2 weeks.
Much obliged.
Item number 7.
My lord, this matter we are appearing for the writ petitioner. My friend is for the respondent.
Who's supposed to file an affidavit?
My lord, we are Mr. Branchi versus Aramarak versus State of Meghalaya.
No. Is there any prayer for an affidavit to be filed? There is an office note dated today. It says an affidavit to bring on record the payment made to the supplier has not yet been filed on behalf of the state respondents.
But early occasion, what happened? They sought time to bring on record that one. In the meantime, we also applied for RDI under RDI. We received the information and we brought on record. Subsequently, the learned AG said since we have brought on record, from their side it's not to bring. But because of that, matter proceed for hearing. Yes. And they are not disputing that document. But it is already in the record. So with Lordship permission, may I proceed with the merits of the case?
Yes. All parties are present?
They are here. Now, what happened, my lord? In 2014, there was a flood, my lord, landslide and flood in North Karo Hills, and brought a devastation in the area. And because of that, my lord, the state respondents has responded to that natural calamities and faced the situation with the public. Now, Lordship, Annexure 1, page 14 of my writ petition. This is the first annexure. These are my notes, my lord.
Just a moment.
This is the, my lord, the minutes adopted by the disaster committee, subcommittee.
Please Start by identifying yourself. You are?
We are the supplier
Oh.
of the items for the. My lord.
You are the supplier.
Yes. And the minutes dated 5/12/2014 will be very clear.
What in particular? You are supplier of what?
For supplier of feeds for animals and poultry.
Oh, feeds.
Feeds, animal feeds.
Yes.
My lord, lordship, kindly come with me to page number 14, annexure 1.
Yes.
May I read, my lord? But the meeting held on 5/12/2014 at such and such in the office chamber of such and such, MCS Additional Deputy Commissioner Revenue, North Karo Hills, Resubil Para, North Karo Hills, in connection with the approved rate of transportation costs and for supply of feed in North Karo Hills district. Member present, my lord. The meeting was chaired by Sri Didi Sangma and such, Additional Deputy Commissioner, who welcomed all the members present in the meeting and initiating the discussion. He gave the brief outline highlighting the objectives and the purpose of calling the meeting. The meeting decided first to constitute a committee in connection with the approved rate for supply of feed on an urgent and emergency need for supply of animals and poultry feed due to a recent flash flood landslide occurred on 22/9/2014 in North Karo Hills. It was occurred on 21 and 22nd, my lord. The committee of the meeting discussed about the approved rate of the transportation of costs and for supply of feed for the animals and poultry feed in North Karo Hills district. After third part discussion, the committee of the meeting has been approved the rate at the rate of ₹35 only per kg for transportation and for supply of feed for animal and poultry feed for the affected people in North Karo Hills district. The meeting approved 3 number of firm suppliers for supply of cattle, poultry feed, and 1 for supply of livestock medicine. Lastly, the meeting was ended with a vote of thanks from the chair. Now, this was adopted by the subcommittee formed by the disaster committee, and they approved the rate of ₹35 to face these natural calamities. Now, they have also approved three suppliers.
So there was no tender process.
My lord, according to me, my lord, tender process is not required. In natural calamities. If the government for tender process, it will not actually breach any.
If the rules provide for it.
My lord, in natural calamities, my lord, tender process is out. Tender process is out. Okay. Otherwise, the objective will never achieve, my lord. Now, the next page. This was the next page, my lord. Page number 15, 5th December. Now, this was written by a Deputy Commissioner, who is the head of the District Disaster Committee.
Yes.
Now, supply of feed for affected animals and poultry due to flash flood, which occurred on 22nd. In view of the urgent need for supply of animal and poultry feed, the following firm supplier may be considered for supply of feed to affected animals as per norms and approved rates of expenditure for supply in the flood affected areas. Number 1, Branji. She is a writ petitioner. Her firm was selected. The copy of your letter dated such 14/11/2014 to the undersigned may kindly be seen enclosed with the approved rates for animal and poultry feeds. The supplier expressed their consent to supply on short notice. This for your kind information and necessary action. So copy was also submitted to me at the bottom. This was written on 5th December. Now on 8th December, the next page, the Director of the District and Animal Husbandry, the officer of the District and Animal Husbandry has written to me this letter. It says supply of cattle feed and pig feed. With reference to subjects cited above, I am to request you to kindly supply the following quantities of cattle feed and pig feed to the.
This is a supply order.
A supply order. Different dispensaries and aid centers for distribution as per list enclosed and submit the bill for further necessary action. Now, 2 items are mentioned here. Cattle feed quantities are mentioned there, and pig feed quantities also mentioned. 2 items are asked to supply. Now, this copy was given to Deputy Commissioner also, Director Animal veterinary department also. Now, the supply was done by page 17, madam, page number 17 of the repetition, the next letter.
Yes.
Madam, this letter was issued to me by the veterinary department again. It says, in reference to letter cited above, I am to request you to kindly supply the following quantities of poultry feed to different dispensaries and health centers for distribution as per the enclosed list and submit the bill for further business action. Poultry feed quantities are mentioned. So I was asked to supply 3 items. It is already mentioned there. Then immediately, my lord, we supplied and faced the calamities together and overcame the situation. And later on, my lord, the 2015 itself, they have issued the utilization certificate, page number 18. This was issued by the district veterinary officer, who was the controlling officer there. My lord.
Yes.
And it is clearly mentioned that certified that such and such quantum and quantums of pig feed and such of quantums for poultry feeds supplied by Brian G, received in good condition and has been utilized for distribution to their families affected by the flash flood, which occurred on 21st and 22nd September 2014 under the guardrails. Such. Thereafter, my lord, we pursue for releasing of the bill. They did not release it. They slip over, they continue, and therefore there was also one communication, page number 19. This was the letter written by Deputy Commissioner. Deputy Commissioner is the head of the District Disaster Committee. Written to the government. He says, forwarding the resubmission of bills for supply of feed for the livestock of the families affected by the flash flood on 22nd. With reference to the letter on the subject cited above, I am to forward here with a copy of the letter under 11 reference received from the District Animal Husbandry and Veterinary Officer, North Karo Hills, Rusubil Para, in connection with the submission of bills for supply of feed for the livestock for the families affected by flash flood on such in North Karo Hills, in respect of Branchi, Mara, supplies and such. It is thus the concerned district veterinary officer, Rusubil Para, has resubmitted the bills challan with the relief camps set up during the flash flood occur on such, along with the necessary clarification, correction, the required information and other necessary papers. The soft copy is also enclosed herewith for your kind information and necessary action from your side. So this is the letter written by the DC to the government. Now, page number 20 again. The Deputy Commissioner again has written this letter on 19 November. It says, with reference to the letter on the subject cited above, I am to herewith a copy of the letter reference received from the veterinary officer, Rusubil Para, in connection with the resubmission of bills and the list of beneficiaries for supply of feed for the livestock of the families affected by the flash flood on such and such. Now, the same reiteration was made, and thereafter, my lord, nothing was happened. Therefore, the writ petitioner has moved to representation to the veterinary officer, page number 21. Page number 21. This was my representation expressing my grievance for withholding the release of the bill.
Yes.
Release of the bill. And they did not respond to. Therefore, the presented petitioner had filed a first writ petition in 2020. And the order is there in page number 22.
Yes.
Page number 22. At the motion stage, it was disposed of on 15/12/2020. Page number 22, Annexure 9. May I read, madam?
Yeah.
Having regard the learned counsel for the respective parties, and after going through this petition along with the annexures thereof, I deem it convenient to dispose of this petition by directing the respondent number 5 to decide the petitioner representation that is such copy of which is annexed such expeditiously as possible and preferably within a period of 4 weeks from the date of the receipt of this order. Accordingly, it is made clear that I have not gone through the merits of the matter, and respondent number 5 shall decide the said representation of the petitioner independently of its own merits and following the principle and nature of justice in accordance with law. In order to enable the respondent number 5 to comply with this order, petitioner shall remain present before the respondent number 5 on such and such, along with the state representation officer. Now, respondent number 5 is the veterinary officer. Now, the next page 23 is my representation raised before the district veterinary officer who was on the ground for implementation.
Yes.
And my lord, the page number 24 is the reply given by the veterinary officer to the petitioner. This reply was made on 4th January 2021. And it says, with reference to the subject cited, I have the honor to inform you that I have forwarded the above mentioned order to the Deputy Commissioner Revenue for necessary action on 23rd December 2020. I am hereby inform you that I have submitted all the necessary papers and bills to the Deputy Commissioner Revenue for payment of the bills, but the office of the undersigned is yet to receive the payment for the same. I will make the payment as and when the fund is made available by the concerned Department of Revenue and Disaster Management. So this was the reply. Now, nothing was happened, therefore I filed this petition. Now the state has filed the affidavit. The state has filed 2 affidavits. May I take the first affidavit filed by the state on the 12th April 2022, filed by respondent number 1, 2, 3, and 4.
Yes.
This was filed by the Commissioner and Secretary of Disaster Management. Now, they have taken the legal para 6, para 7, and I will. Para 6, they have taken the plea that there is a delay of filing the writ petition here.
Yes.
Madam. With that, my lord, may I respond that the delay is not an issue anymore. We came to the court 2020 and asked the government to consider, and they have considered my representation. They never say that because of delay in latches, we cannot consider your case anymore. Rather, the government said that we are considering, as and when fund is available, we will give it to you. So the question of delay in latches doesn't arise here. Now, number 7 also, my lord, is a legal plea. Most of the affidavit filed by the state respondent, these are the plea always incorporated in the affidavit. It is not relevant. Now, para 8 is relevant, my lord.
Yes.
The stand taken by the government. May I read? It is submitted that the writ petition is also bereft of material except for the minutes of the meeting allegedly took place on sunset for approving rate of supply of feed. It is also relevant to note here that no document has been shown that the approval of the government of Meghalaya has been obtained for approving rate of supply of feed. Further, the perusal of the minutes of the meeting dated such allegedly show that in the alleged meeting chaired by such ATM Revenue, what was the basis of approving the 3 firms, suppliers, supply of cattle and poultry feed, is a matter of record that the empanelment of the supplied firm for supply of feed to government have to be carried out in a fair and transparent manner as per the government of Meghalaya memorandum. It is clearly stated that only purchase above 50 lakhs has to be done in fair and transparent manner.
50 lakhs or 50,000?
50,000, madam. 50,000. I'm stand corrected, madam. Even assuming without admitting that the order was placed by Deputy Commissioner Revenue in violation of the government order, the same is illegal and without any authority and it cannot bind the state government. Now here they have taken the plea, my lord, that they have to follow the selection process, or for example, the tender process. Nowhere disaster management spell provided that one. Although therefore, from the beginning, I said that would really defeats the purpose of meeting the natural calamities. Now, state is projecting that purchase above 50,000. It requires fair, transparent manner. My lord, this is often the government memorandum is not applicable in this case. And second plea they are taking is that approval was not obtained from the government. Now, the approval was given by the subcommittee, district disaster committee, and nowhere from the beginning, from 2015-20, nowhere they say this approval was never taken. We cannot proceed this. The government never says. Rather, you bring the proper bills. There is shortage of papers, supply of particulars. You bring so that amount. The conduct of the government shows that they admitted that yes, there was a natural calamities, and natural calamities was met by the government with the support of this petitions and other. Now, therefore, they say that the action taken by the Deputy Commissioner is not binding. I'll come to the Disaster Act, Madam. Disaster. District Disaster Committee, headed by DC, is a statutory body, Madam. They cannot say the decision taken by this Disaster Committee is not binding to the government. They cannot do that, Madam. They cannot do that. And admittedly, if that is the case, what action government has taken against the government and those committees? No way, Madam. So therefore, the plea taken by the state in paragraph 8, Madam, do not support by law, Madam. In paragraph 10, Madam, paragraph 10, may I read, Madam? It's important. It is submitted that the perusal of the letter of the Deputy Commissioner and Exchequer shows that the petitioner has given a letter and such even prior to the meeting of the committee to allegedly disapprove the raid. It appears that, Madam, letter 20, Madam, 2411. It appears that the entire transaction is shrouded in mystery and has not been carried out in a fair, transparent manner. It is further submitted that even a perusal of the letter of animal husbandry and veterinary officer dated such, it is not clear as to how animal husbandry and veterinary reach or arrive at the quantity of cattle feed and pig feed. There is no assessment to show how many animals are stranded or requiring cattle feed or pig feed after 73 days of flood. Similarly, the order dated sunset placing further order from supply to supply poultry feed is also without any basis, and no reason has been given as to why poultry feed having quantity of sunset. So they are disputing, my lord. There is the ground officers say that we need this one, issue supply order, we supply, my lord. Now the commissioner and secretary, my lord, he is not the assessing authority. He is not the assessing authority, my lord. Now the para 11, it is submitted that the petitioner has also not placed any document, voucher, receipt, etc. that he has supplied quantity of cattle. I'll come to the letter of the officer that they have supplied all the documents, all the documents. Now para 6, para 16 also may come. Para 16, my lord, 17, my lord. They are saying that, my lord, the appeals are not properly submitted. Therefore, one cannot ensure that supply has been made. Para 22, 25 also. Now, this was the reply. So the government is projecting in substance in this affidavit that the contract is in dispute. Contract is in dispute. According to me, my lord, government cannot dispute. When the appropriate district disaster management maintain the minutes, place an order by the veterinary officer, contract has been given, utilization certificate has been given, detailed vouchers and the bill has been supplied by the petitioner to government. Now, there may be internal communication between the departments. That cannot be the ground to deny the rights to the petitioner. Now, the matter was filed and, my lord, the veterinary officer was not filed the affidavit. This was taken cognizance by the earlier bench. And therefore, we array them as a party because he is the one who implemented, who is in the ground. Therefore, he filed the affidavit. And his affidavit may I take, my lord. Respondent number 5. And his affidavit is very clear. The entire affidavit, the contention taken by the state respondent in the first affidavit is absolutely, my lord, incorrect. Now,
so there is a confusion within the department.
My lord, I'll come, my lord. Para 1 to para 5 to, my lord, para 17, these are the pleading regarding the law points. My lord, I don't need to reply as of now. But para 18 onwards, my lord, will be very clear. Para 18 onwards of the affidavit. Page number 10.
Yes.
May I take my lordship attention? That based on the official records, it is submitted that severe flash floods and landslides struck the Karo Hills in the month of September 2014. The floods caused a large-scale destruction in the region and necessitated urgent relief and rehabilitation measures to be taken. One of the relief measures was to provide for necessary feed for affected animals and poultry. Accordingly, White Leather Sons and Sons Search, veterinary officer, this Karo Hills, initiated requests for supply of animal feed and poultry to short notice. Now they said, my lord, the requirement was made by the department. After inquiry, it says, Disaster District Management Committee, White Leather 2411, identified the petitioner as one of the firm supplier who was in a position to make available the necessary stock piles of feed on short notice. On 5th 12, the Deputy Commissioner convened another meeting of the District Disaster Management Committee for addressing the issue of supply of animal and poultry on short notice. The 3-member committee fixed the price at the rate of sunset, which is consistent with the rates prescribed in this regard as per the revised list of items and norms of assistance from State Disaster Response Fund and National Disaster Response Fund, as per the MHA letter 2012. Now, he admitted that the price fixed by the subcommittee is in consonance with the existing rates. The applicable legal provision under which the above requisition was made is para 6.2 of the State Disaster Response Fund and National Disaster Response Fund. They have made an annexure. Now, para 22, it is also to be noted that the State Disaster Response Fund is constituted under the section 48 of the Disaster Management Act and is a primary fund available with state government for response to notified disaster. Central government contributes 90% for special category states, northeastern states, Uttarakhand, Himachal Pradesh, and J&K. That in the above manner, the short notice supply order was issued to the petitioner herein after due approval of the District Management Authority. It is apparent from the records that on 4/10/2018, the Deputy Commissioner forwarded the bills along with the certification received from the veterinary officer, not Karo Hills, to the state government through the Deputy Secretary. It is at this stage that the state government, through the Revenue and Disaster Management, raised certain objection as to the clearance sought for the bills. Now, the clearance sought is for what purpose? For the bills. They are not saying that the rate is not correct, there is no contract, they are not seeking that one, madam. Only the bills. This was conveyed by the Deputy Commissioner via letter and such, wherein in the earlier the following information in connection with the writ petition was sought. Copies of the supply orders, whether the distribution of fodder was done in cattle camps and the number of days in which the cattle was housed in the camps. It appears that the quantities were raised to certain compliance with the requirement of para 6.2 of the State Disaster Response Fund and the Central National Disaster Response Fund, which is pertaining to Sons and Sons. That White Letter 16 October 2015, the office of the veterinary officer informed the Deputy Commissioner that the relief camps had not been set up due to various reasons, including reluctance of the villagers to bring the cattle to these camps on account of fear of misidentification, etc. Therefore, the fodder was utilized by distributing the same through the headman. So he was saying that there was a resistance from the villagers. Therefore, the camp was not there. Now, later on, that was a later communication 2015. That in the respective submission, it is in the respective submission of the respondent herein that the above decision was taken bona fidely. However, in view of the revenue and disaster management, is that the arrangement of not having cattle in the relief camp is contrary to the requirement of para 3.4.2 of the State Disaster Fund and National Disaster Fund. Concentrated including water supply and medicines in cattle camps. This, in essence, is the point of difference. Not only, my lord, page 15, my lord.
Yes.
The officer is saying that the difference between the veterinary department and the government is that whether, my lord, the feed was supplied in the relief camp or not. That is the point of consideration. Now, in the subsequent paragraph, it is in the light of the above difference that the government of Meghalaya Revenue Disaster Department, White Letter and such, refused sanction for amounts for payment, as in the opinion of the Revenue Disaster Management, it was a substantive requirement of para 6.2 of the Disaster Fund, which pertains to animal husbandry, assistance to small and marginal farmers, provision of fodder, feed, concentrate, including water supply, medicine, relief camps. That therefore, in the humble submission of the petitioner, it should be of the respondent, deponent should be deponent. The present case is not one of any wrongdoing. or the case where sanction has been refused by the government on the basis of the alleged non-compliance of the terms of the above guidelines by the supplier. Now the veterinary officer is saying that it is not an act of wrongdoing.
Okay.
Wrongdoing. Now subsequent
So
para.
in a sense, he's supporting your case.
Yes, exactly. And he's the one who controlled the on the ground in district level. Who is the one who implemented. Now, para 29, my lord. Subsequently, the bills were accordingly revised along with the list of relief camps and resubmitted by the office of the district animal and husbandry veterinary officer to the state government through the deputy commissioner by letter such 2018. It is noteworthy that the district animal husbandry veterinary officer in his letter 2016 has admitted that this previous bill submitted was wrong. The same is regretted. So earlier letter submitted, which he says that there was no relief camp, was by mistake. So he regretted. Now, para 30, my lord. By a letter 2016, the district and veterinary officer admitted having mistakenly indicated on a previous occasion that the distributor fodder was not in the shelters. The officer reiterated that the distribution was in fact in relief camps and therefore requested that the sanction may be accorded for the same. So earlier communication was incorrect. In fact, distribution was in relief camp, so sanction may be accorded. Now, thereafter, no sanction was received for payment to the petitioner, perhaps due to the issues set out herein above. And in this background, after delay of nearly 7 years, the petitioner representations and such raised demand for clearing the bills, which was forwarded by the department by pointing out that the funds are not been received from the Revenue Disaster Management Department. It is submitted that the claim is therefore not tenable in law and liable to be rejected on this ground alone. So this, all throughout, he supported my case. And para 32 says that I don't have a case. Now, in substance, my lord, he admitted that contract was there, supply was made, the rate was duly fixed in consonance with the prevailing law, my lord.
Yes.
And the annexures, my lord, page number 22, the paper he has annexed.
Yes.
My lord, page number 22. Now, this is the guidelines prepared by the government, 21 June 2013. Now, they refer, the state refer, veterinary officer refer to this page number 24. Page number 24, point 6. One refer to poultry.
Yes.
And point 2, page number 25, the next page. Roman 2, provision of further feed concentrate, including weather supply and medicine in gather camps. Now, this is the bond of contention between the two, the department itself.
Okay.
This was the confusions. Therefore, the veterinary officer said that early 2015 communication was wrong. We stated that there was no camp, but we relooked the matter, and it was in fact distribution was done in the camp. So this was fulfilled.
Okay.
After this, my lord, the disaster department is supposed to sanction the amount. Now, transport of fodder, the Roman number 3 also important. Transport of fodder to gather outside gather camps. Even supplying outside the camp also permissible. But now disaster is focusing that it should be only in the relief camp. Though the veterinary officer, it was subsequently done in the relief camp also. Therefore, the claim of state government that it should be only in the relief camp is not absolutely correct also. Now, the letter written by the, well, page number 27. This was the first letter, and this created the confusion, 2015 letter, 16 October.
Yes.
This was written by the veterinary officer to the deputy commissioner. He says, setting up relief camps for livestock during the flash flood, sunset. With reference to subjects cited above, I have the honor to inform you that the relief camps for flood-affected livestock could not be set up during the flood due to shortage of manpower. Moreover, the affected villagers were reluctant to bring their livestock and poultry to the relief camps due to the fear of misidentification and misplacement. Most of the affected villages are in interior areas, and the roads and bridges connecting to their villages have been washed away during flood, making it all the more difficult to bring their livestock and poultry to the camps. So the relief camps meant for them are left unused. Now the relief camps are there, madam. Now he is talking about the unused. And the feed for livestock poultry were distributed through the village Konpuras, Nogmas, Sertas and Village Employment Council members for proper distribution in their respective villages. So this was the letter. Now, my lord,
Yes.
the second letter, my lord, page number 28. He made clear, they realized that, my lord.
Yes.
Now this was written by the, my lord, the government to the Deputy Commissioner. Now it says, my lord, I am directed to refer to the letter cited above and to say that item 6.2 of the State Disaster Response Fund norm states that provision of further feeder concentrate, including water supply and medicine in cattle camps. Since feed were supplied outside the cattle camps, the proposal of sanction of fund out of sunset for payment of bill is not eligible under the items and terms of the State Disaster Response. So this was the letter written by the government to the Deputy Commissioner.
Okay.
Deputy Commissioner. They are saying that it should be only in the camp. In the camp. Though the rule says that even outside the camp permissible. Now this is the step. They are not saying that there is no contract. They are not saying that the rate is not approved. State did not approve the rate. They are not taking that plea. Only the camp. Now, after this, my lord, the letter, the corrected letter was forwarded. My lord, may kindly see page number 30 of the same, in the same affidavit.
Yes.
There you see it was written on 14 April, 19 April, written by the veterinary officer to the government, to the DC. In reference to the letter number cited above, I have the honor to submit here with the bills and other related papers of branch, along with the list of relief camps set up during the flash flood that occurred on Sunset. The earlier clarification regarding setting up of relief camps were a mistake and is highly regretted. This is for your kind information and necessary action. Now, enclosed area of distribution, beneficiary list, village abstract, Chalan bill, utilization certificate, photo, and list of relief camps. So details have been submitted. So earlier was 2015 combination was wrong. Now this is the correct one. So he has written to the the commission along with the 11 papers. And the next page was page 31. Page 31. He has written again to the Deputy Commissioner.
Yes.
Reference cited supply. I have the honor to clarify here with that in connection with those letters, it was regretted that earlier clarification regarding setting up of relief camps for flood affected livestock as a mistake. The feed was distributed through relief camps as per enclosure. The relief camps duly approved by the Deputy Commissioner Karo Hills Reservoir Para is also attached herewith. This is for your kind information action now. Relief camps certifications. So all the papers has been submitted by the veterinary officer to the Deputy Commissioner. And now the last letter, my lord.
Yes.
May I take your lordship attention to page number 29. Page number 29.
29.
29 now in the same affidavit, madam.
Yes.
This was dated 28 September 2018. Now, referring to the letter cited above, it says, I have the honor to state that in the bills submitted earlier, there were miscalculation in the amount of the bills and quantity of the feeds distributed, which has been duly corrected hereby, and for which it is regretted highly. The clarification regarding the general observation from the local auditors also enclosed with. This is for your kind information and necessary action. Enclosed connected challans, bills, corrected quantity of the feed distribution list, photos, and clarification. Now, Lordship, remember the first affidavit filed by the government say that there was no bill, no vouchers, no papers. Now, the officer of the state itself, that the details are there, submitted to the District Disaster Management Authority. Therefore, the affidavit filed by the veterinary officer, who is in the district level, controlling officer, completely clarifies the actual factum of the position, that the contract was there. Number two, rate was fixed accordingly, supply was done, the quantity was fixed, and the deal bills were submitted. There was some mistake was there in 2015. Stood corrected and urged the government to sanction it. Now, state government is trying to make out a case in their first affidavit that there is nothing. There is nothing. Now, if there is nothing, my lord, the government cannot say. Government officer report says the supply has been done.
Yes.
The higher officer in the state level, without any materials, is there any reports submitted by any authority that there was no contract, no rate was fixed, no quantity was fixed, no supply was done, no relief came? Nothing is there. In the AMI law, they have taken a plea in the affidavit. I'll come to that Supreme Court decisions. The state government or the respondent or the petitioner cannot take a plea without supporting evidence in the pleadings. Now, may I come to the one factor? Now, they last affidavit. Bring on record. Now, what happened? 3 suppliers were selected. They do admit it. Out of 3, I came here. My friend Mr. Sujit has come here. There is one gentleman who did not approach before this honorable court. Now, silently, methodically now, when we pursue the matter here, what they have done, government has sanctioned the more than 1 crore to the 3rd supplier, who is not before this court. Now, the same contract, the same disaster, the same natural calamities, the same authorities, the same controlling officer. Now, I take the particulars, my lord, in my affidavit, 26/6/2023. With the permission of this honorable court, I brought on record this.
Yes, this is
this filed by me. Affidavit bring on the relevant contract papers of the firm, MS Contempt Enterprise. In para 2, my affidavit, my lord. Para 2 of the affidavit, my lord. Page 3, Annex A, letter addressed to the Deputy Commissioner, selecting the firm. Annex P, my date also mentioned there, my lord. The MS Contempt Enterprise to supply cattle feed. Quantity also mentioned. On 21/1/2015 also is there. Subsequent page number 4 also. Sanction order, my lord. 17 March 2023. Now they are sanctioning the amount, the PL amount to the Contempt Enterprise on 27/3/2023.
so Contempt Enterprise is also one of those.
Yes, one of selected. Now I'll come to the annexures. Lordship, may kindly come to page number 7 of the same affidavit.
Yes.
My lord, this was written by the Deputy Commissioner. Selection of the MS Contempt Enterprise. And this same annexure we made in page 15 of my writ petition. Same. Well,
yes.
In view of the urgent need for supply of animal and poultry feed, the following firm supply may be considered for supply on an urgent and emergent basis following the relevant and necessary norms and approved rates of expenditure for supply in the food flood affected areas. MS Contempt Enterprise, they have selected. It's an urgent manner. If it is a natural calamity, where is the procedure for following tender process? My lord, public tender process. Now this was the letter, same annexure we made in page 15 of my writ petition. Now page number 8, my lord.
Yes.
Communication to the MS Contempt, my lord, by the veterinary officer. The same officer has selected, informed me also in page number 16 of my writ petition. Informed the Mr. Contempt that you are selected, you are directed to supply these cattle feed, pig feed quantities. They have mentioned. It is the same, my lord.
Yes.
And now, page number 9 also, my lord. 9 also. He was also directed to supply the 3rd item. Reference to letter cited above, I request you to kindly supply the following quantities of poultry feed to different dispensaries and aid centers for distribution as per list enclosed and submit the bill for further sunset. Poultry feed, quantity mentioned. The same thing to the writ petitioner. And the next page, page number 10, utilization certificates issued by the same authority, like the writ petitioner.
Yes.
Well, in 2015, to MS Contempt.
Yes.
Now, page number 11, the development that has been taken place when 2 of us are pursuing the matter before this court, and this development took place in the government. Sanction order, my lord. 27 March 2023. Now may I read, my lord? In pursuance to the sanction letter dated 1/3/2023. Now, in my case, they're talking about the delay in ledges. Whereas the other person, my lord, sanction is on 1/3/2013, resolved from the Undersecretary to the Government of Meghalaya, Revenue Disaster Department Shillong, an amount of rupees 1,35,29,000 such is hereby sanctioned and released to the following suppliers, being the partial cost of supply of medicines and livestock, fits sanctioned by the state on account of pending settlement of the observation on bills made by such to the affected families during the flash flood landslide on September 2014. Same occasion, madam, and say the sanctioned by the government.
Okay, please.
For
So for the same occasion, which means that for that period where the disasters took place.
Right.
And these have been, these firms have been shortlisted and ordered,
Right. 3 of us were shortlisted. 3 of us received the sanction letter, and we supplied the fits, everything, for the same purpose, the same area, Karo Hills, not Karo Hills. And now we are before this court, and this gentleman, Ms. Gautam, he is obtaining a sanction of amount from the government, and he has been paid.
He has been paid.
He has been paid. Okay. Now, serial number 2, Ms. Gautam. Ms. Gautam. Okay. And the credit amount payment advice, my lord, page number 12. Dated 28 March 2023. Page number 12, madam.
Yes.
It says we authorize the bank to credit _ account maintained with the bank with amount of credit beneficiary annexures and such. Now the annexure, madam. Yes. Now the amount is mentioned in the page number 13. Name of the beneficiary.
The amount, this down, okay.
Madam. Page number 13 is relevant. The last page.
Yes.
Name of the beneficiary, MS Gautam Enterprise.
Okay.
And the amount is mentioned there. 1,26,06,200 was sanctioned to him.
Yes.
And it says it is a part payment. And complete payment cannot be made because of the certain observation by the department.
Okay.
So in his case, government is settling the bill. Whereas in my case, the government has taken a bold face to reject my petition. Now, may I come to the disaster? Before I come to the plan, my lord, I come to the act. Well, I have submitted the act, disaster management. It is there.
Yes.
My lord, the act provides, my lord, the certain authorities for meeting the natural calamities. Section 3, my lord. Lordship, can you take section 3? Section 3 talk about the formation of the National Disaster Management Committee. This is the highest apex body for the disaster. And we will come to the relevant one.
This is not in dispute.
My lord. Section 14. Section 14. Establishment of State Disaster Management Authority. Now, this is the apex body in the state level, headed by the chief minister. And now this third body, my lord, I will show, is the, my lord, Lordship, may kindly come to section 20. State Executive Committee.
20.
My lord, the State Executive Committee is headed by Chief Secretary.
Yes.
And Section 25 may I come. District Disaster Management Authority. Section 25.
Yes.
It is headed by the Deputy Commissioner or Collector of the district.
Yes.
And now Section 28. Because they are saying that the rate was not fixed by the appropriate authorities. Now Section 28.
Yes.
It says, my lord, Constitutional Advisory Committees and other committees. The district authority may, as and when it considers necessary, constitute one or more advisory committees and other committees for the efficient discharge of its functions. Now, District Disaster Committee, headed by Deputy Commissioner, constitutes 3 committee member. Now,
this is as per Section 30.
As per Section 28.
Oh, sorry, 28.
Section 28.
Yes.
Now, we come to the rules framed by the government. Each state government has the power to frame the rules, and they have framed the rules. Now, the next page, my lord. The next page, my lord. Composition of the State Disaster Management Authority. Section Rule 3. Headed by Chief Secretary, Chief Minister. Now, Rule 7.
Just one. This is the 19 July 2010.
My lord, it is not date of notification.
Yes,
date of notification. And the rule is available from the next page.
State rules, no? Is it?
My lord, state rules.
Notified. Yes. Yes. So
now, Rule 3, my lord, we see. Rule 3 is the composition of the state authorities.
Yes.
And Rule 7 is the executive committee composition, lord, you can see.
Yes.
5 members committees are there, headed by Chief Secretary. And now, my lord, the Rule 10 is the composition of the District Disaster Management Authority.
Yes.
So this composition was formulated by each state government, and this is the composition in the state here. And Rule 12 is the composition of the formation of the other committees. Now, this is the position in the state. Now, central level, let us forget for the time being. State 3 authorities are there: state level, executive level, and district level,
yes,
and other committees. Now, state has formulated the plan. I'll just show. Now, this plan was formulated by the government under the Act in 2016.
Yes,
I take a relevant portion. The first flag mark.
Yes, yes, sir.
The first, Lordship, kindly come to first flag mark.
Yes.
My lord, here it indicates illustration of district affected by landslides. My lord, we come to 2014 in the table, my lord. 2014 in the first flag mark. Now, when we go there, now 27 times, my lord, North Karo Hills.
Yes.
So in 2014, 27 times natural calamities are there. Now, may I come to the flag number 2.
Yes.
Flag number 2. And my lord, may I come to the next page, page number 71.
Yes.
Point 9.8, District Disaster Management Authority.
Yes.
The plan says, my lord,
Yes.
Deputy Commissioner, Chairperson, Chief Executive Member, those are the my lord. May I read, it will assess the disaster and provide instructions to the concerned departmental heads in the district for better management of the disaster situation. It will assess the situation by taking into consideration the reports from all sources and decide upon the level of the disaster. It will also give guidelines for handling the response, relief and restoration measures during the crisis. It will make assessment of the available resources and issue necessary direction for pooling resources from different sources. Now, the appropriate authority to assess the situation is the district disaster, not the state authority or not the state executive. Now, the last flag may I come. Third flag.
Yes.
Flag. Chapter 14, madam. Livestock management. Chapter 14.
14.
Yes, madam. Livestock management during emergencies and disasters. It says the Department of
third flag is
madam, the third flag, madam, the page, the other side of the page, madam.
Yes, yes. Yes.
Madam, the Department of Animal Husbandry and Veterinary, Government of Meghalaya, is entrusted with the responsibility of all aspects of livestock and poultry development, as well as preparation of disaster management plan for livestock. So, regarding this nature of disaster for the animal and other, it is the, my lord, the veterinary department on the ground, the department. And now the department says that yes, contract was done, supply was done, particulars are there. Now the state government in its affidavit are disputing this. This is not permissible. Now, may I come to the last page, my lord, page number 90 of that third flag. The page is reflected at the bottom.
Yes.
Point number, my lord, 14.43, response. The thing is this one.
14.3.
Well,
yes.
Well, it says, well, all animals shall be evacuated and taken to shelter as soon as there is a news of an imminent disaster. Every animal must have some form of durable and visible identification. For instance, the animal should be branded or tagged, and the community should have an arrangement for appropriate transport suitable for specific animals. Since animals will be displaced and will congregate, resulting in the increased potential for disease transmission, early intervention to the support animal health is likely to be highly cost-effective. Facilities provided for displaced subsistence farmers should include separate facilities for animals in the relief camps, as it is crucial to keep the animals and people apart. The animals should be vaccinated and treated if necessary upon arrival. Human vaccination program should cooperate with the animal vaccination program, as the vaccination program for humans have been shown to have a high success rate when conducted in concurrence with the animal vaccination programs. Following floods or cyclone storm, large numbers of carcasses are often found scattered, while many carcasses in remote areas would be scavenged. Carcasses lying close to human or animal in habitation or water sources should either be removed or destroyed rapidly. Composing on site may be the most practical alternative in many cases to dispose of large carcasses. It is important, madam. Stranded animals should be rescued and taken to safer places. In a stranded place is considered safe for the next week or so. The animal may be left there, but they should be provided feed, fodder, and drinking water. Arrangement could be made so that the veterinary and staff, paramilitary personnel can quickly reach all affected animals to provide treatment, vaccination, and or deforming. Officers and other personnel engaged in relief work should also be gathered intelligence on the context and nature of the damage to the individual farms and villages to that appropriate measures to be taken. But what I'm trying to bring home is that it is the veterinary department who is manning the ground, on the ground. And what they say is, their affidavit is very clear. Therefore, state has no right to dispute this. If they are disputing, they are not disputing me. They are disputing their own department. Well,
Yes.
the entire obligation is casted upon the veterinary department. They have executed duties. Well, now, may I take some decision? My lord, the respondent has taken the plea that this nature of contract do not call for consideration by the writ court. Well, therefore, it should be dismissed. There is a disputed question of facts. That is the question raised by them. Now, according to me, there is no material shown by the government. What area they dispute? The veterinary department say that everything is in order. Now, the state government, in its affidavit, it is disputed. Merely taking the plea in the affidavit that there is a dispute, it doesn't mean that there is a dispute in the case. Now, in these circumstances, my lord, one amount they are not disputing. The amount, it comes to me 2 crores something. But it is not the case of the government say that amount is disputed. They are not saying this.
So amount is not disputed.
The amount is not disputing. The contract, my lord, the contract is not disputed by the veterinary department, who control the entire exercise. Now, the officer who never involved in the ground, my lord, is disputing in affidavits without any materials.
Yes.
Therefore, the writ is maintainable. My lord, may I take the citation? Lordship, may I take to the flag 1, para 12 onwards. Para 12, may I take 12 onwards, madam. May I read, madam?
Yes.
But the above aforesaid decision does not lay down in absolute rule that in all cases involving disputed questions of fact, the parties should be relegated to a civil suit. Suffice it to refer to the unambiguous observation made by the Apex Court in the Century Supply and Manufacturing Company Limited versus and such, 1917. Merely because the question of fact is raised, the High Court would not be justified in requiring the party to seek relief by the somewhat dilatory and expensive process by a civil suit against a public body. The question of fact raised by the petition in this case are elementary. The writ court entertains the writ petitioner for direction to the authorities to pay the undisputed amount of appeal to the writ petitioner. Regarding this settled position, it may not be required to burden this court by citing number of cases in which the High Court, by invoking the writ jurisdiction, had directed the authorities to release the undisputed amount of the appeal to the writ petitioner. For the foregoing reason, this court is of the considered view that the respondent cannot withhold this undisputed amount of appeal, rupees and such, after the petitioner had fully supplied the textbooks in compliance with the terms and conditions of the quotation notice for supply of textbooks dated and such, and the supply order dated and such, in clear violation of the terms and conditions of the quotation notice for supply and such. In the result, the writ petition is barely allowed by directing respondents to pay the said amount of rupees and such. So here also, my lord, in this case, respondents say that there is a dispute question of facts. Now, in my case, my lord, the department at all did not dispute. And in the affidavit itself, they cannot dispute. If there is dispute, my lord, by the state government, where is the substantial material to support their contention? There is no materials. Whatever, my lord, the direct practical encounter implementation by the department is the veterinary, whose affidavit is very clear that the contract was performed. Now, other point, my lord, may I cite 2016-1 SCC is one of the important, my lord, important judgment. 2016 volume 1 SCC. Page number, page number 724, para 4.
Para 4.
Para 4, my lord.
Yes.
May I comment? Para 4.
Yes.
There cannot be gainsaying that every decision of administrative or executive nature must be a composite and self-sustaining one. In that it should contain all the reasons which prevail on the officer taking the decision to arrive at his conclusion. It is beyond cavil that any authority cannot be permitted to travel beyond the stand adopted and expressed in it in the impugned action. If precedent is required for this proposition, it can be found in the celebrated decisions of titled such and such, my lord, such.
Yes.
The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds later brought out. We may here draw attention to the observation of Justice Post and such. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant, or what was in his mind, or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed, and must be construed objectively with reference to the language used in the order itself. Orders are not like an old wine, becoming better as they grow older. But therefore, by the decision I'm citing here is that the state government, in its affidavit, is citing a reason which is not part of any record, not part of record, part of record. Now, and second position is, my lord, the facts displayed by the veterinary department, my lord, the government cannot dispute it, and they are disputing it without any material support. The reason they are supplying in the affidavit. Therefore, the apex court said this is not permissible. Okay. Permissible. There is no communication 2015 to 2020 that it was not approved. No contract was signed. No supply was done. That is not the case. They are saying that the relief camp, whether you supply in the relief camp or not, because of that miscommunication, that is the only one.
But that has been clarified.
That is good. That was clarified. Now, another point, my lord, I think the decision, but the facts, my lord, 1988, volume 4, SSC.
1988.
88, my lord. 1988, volume 4, SSC, page number, my lord, 534.
Yes.
My lord, may I come to para 13? Para 13 is a well settled, my lord, well settled law about the pleadings of the parties, especially when the citizens are before the writ court. Yes. Para 13, my lord. May I read, my lord?
Yes.
As it has been already noticed, although the point as to profiteering by the state was pleaded in the writ petition before the High Court as an abstract point of law, there was no reference to any material in support thereof, nor was the point argued at the hearing of the writ petition. Before us also, no particulars and no facts have been given in the special writ petition, or in the writ petitions, or in affidavit. But the point has been sought to be substantiated at the time of hearing by referring to certain facts stated in the said application by such. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the petitioner, writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded, or the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain that point. Such a point. Now, in my case, my lord, the respondent taken the plea. But where is the materials? Where is the report that I have conducted the survey, detailed survey, and the survey report show this one? There is nothing. Is there? There is nothing. But They cannot take a simple the plea in the affidavit. Yes. So this is contrary to law. Another point, my lord. I may cite 2012 volume 9 SSC. A person who committed wrong should not gain the benefit of the wrong he has committed. That is the law. Para may take, my lord, may take to para 28 and 29 may take to my lord, to save lordship time. Para 28 and 29. Page number 3,
yes.
1, 2.
319.
My lord. Now, made in para 28. A person alleging his own infamy cannot be heard at any forum. What to talk of a writ court, as explained by the legal maxims such and such. If a party has committed a wrong, he cannot be permitted to take the benefit of his own wrong. But may come down. Thus, it is evident that the appellant has acted with malice towards the respondent, and it is not merely a case of discrimination, rather it is a clear case of victimization of respondent number 1 by the school management for raising his voice against the exploitation. I may not go to the background of the case. Here also, the department has committed mistakes and the respondent was victimized. Here in my case also, there may be a mistake committed by the department or the other communication gap was there. I cannot be victimized. I cannot be victimized. And the state is trying to derive the benefits out of that. That is impermissible. Impermissible. Now, with the same line, 2004, volume 1, which is more clear. 2004, volume 1, SSC. Para 4, Para 4. At this page number 139. Para 4,
Para 4.
Para 4.
Yes.
My lord, may I take a para 4. Having heard the learned counsel for the parties, we are satisfied that no case is made out for interference with the judgment of the High Court. Before the High Court, the principal plea of the respondent was that there was no contract in writing, and therefore the applicability of the principle of promissory estoppel was not established. The High Court has highly discarded this plea. To attract the applicability of the principle of estoppel, it is not necessary that there must be a contract in writing entered between the parties. We are not satisfied even prima facie that it was a case of an error committed by the state government of which it was not aware. The state of Orissa should have, while holding out the representation, taken into consideration the fact who will have to do the replantation and that the permission of the government of India should be needed for the purpose. The state cannot take advantage of its own omission. The state government having persuaded the respondent to establish an industry, and the respondent having acted on the solemn promise of the state government, purchased the raw material as a fixed price and also sold its products by pricing the same, taking into consideration of the price of the new material fixed by the state government and supplied. The state government cannot be permitted to revise the terms for supply of raw material adversely to the interests of the respondent and effective from the back date, and place the respondent in a situation where it would not be able to resolve. The respondent could not have been revise its price from a back date and recover it from innumerable consumer to whom it is finished products were supplied at a fixed price. Here also, my lord, if we go to the fact of the case, the state government claimed there is the mistakes and they rectified it. The government say that once you commit mistake, you cannot take that take the benefit of that wrong. Now, in my case, my lord, here it was about the promissory estoppel. What promise given to me? But you say, my lord, there is no formal contract ended between me and the government. It is a disaster management. My lord. But the conduct shows that there was a contract between me and the government. It was enforced. It was enforced. My lord. Therefore, the principle of estoppel is applied to the government, that you cannot take a U-turn now and say that there is no contract. So that is not sustainable. So my humble submission is, I was subject to respond from the London HA and my rejoinder.
Yes.
My lord, this is a case where discrimination is done. Another third person was wrongly selected, sanction was made, arising from the same contract, same disaster, and a citizen who approached before this court with folded hands seeking justice is deprived, discriminated. My lord. And state has taken a bold face in the first affidavit without any materials. that it is not sustainable. Well, the prayer made by the petitioner may be considered. I pray. Thank you. My friend can advance. He's one of the petitioner, and Learned HE may give a consolidated reply.
Exactly the same.
You are also in this petition?
Yes, not in this petition, my lord. Item number 8 is the same contract, and on the basis of the same meeting, my lord.
The same flash flood, my lords, for same period. My friend's claim is 6 crore rupees. The other matter, for supplying the cattle feed for 73 days or thereafter, my lord, the claim is in the tune of all 3 contracted crore rupees, my lord. For 2014.
If my lord may kindly stay the next item, just place few papers, my lord, which will clarify the matter in better way, my lord. Because my learned senior has apprised this honorable court that in details, my lord. Only 2 or 3 things that I want to point out in addition to my learned senior's submission. My lord, if my lord may kindly take the item number 8.
So you, Mr. Kumar, you will reply for both the...
I will, yes, both the matters, my lord. I will reply to the matter. Yes, my lord, common reply. Their facts are similar, the claim is almost similar, but my lord, I need to go through the judgments which have been cited by my friend at the bar, my lord, because I have to show that those judgments are not applicable. Those judgments are distinguishable on fact, on law, my lord. So I would say...
Then what we can do... Yeah, what we can do is Mr. D. Yeah, Mr. D can submit, and you can reply on the next date.
Yes, sir. I will do that. I will do that.
Okay.
If I may kindly take the writ petition 359.
Yeah.
Here, my lord, the petitioner who was before this, initially who was the petitioner, he already died, my lord, out of cancer. He was pursuing this matter, and then subsequently we have substituted his wife, my lord. Now the wife is before this honorable court. If my lord may kindly come to Annexure 1, page 28. My lord, is not readable. The type copy is on page 30, my lord.
Page?
30.
Okay.
My lord, this is the meeting which was held in the chamber of the Additional Deputy Commissioner Revenue, North Garo Hills, my lord, on 5th 12 2014 at 11:30 AM, my lord.
Yes.
And this meeting resolved certain resolutions, my lord. If my lord may kindly see, they have said in resolution number 1, my lord, in the meeting, that on 22nd 9 2014 in Garo Hills, there was a landslide and flash flood, my lord. And my lord, the senior has also pointed out that how many times there was a natural calamities in North Garo Hills, my lord. Now, my lord, may kindly see in serial number 3.
Yes.
After chairman discussion, the committee of the meeting has approved a rate of rupees 35. This rate has been approved by the committee, not by the supplier, my lord.
Yes.
Now, my lord, number 4, if my lord may kindly see number 4, serial number 4, the meeting approved 3 farms supplier for supply of cattle and poultry feed, and 1 number for supply of livestock medicines, my lord.
Yes.
So, my lord, these 3 farms. So, I am one of the farm, my lord.
Yes.
Now, my lord, may kindly come to Annexure 2, page 32, my lord. Again, it is not readable. My lord, may kindly come direct to page 34, which is type copy, my lord.
Thirty-four,
my lord. Now, my lord, may kindly see. This is a letter which was addressed to me, my lord, to my late husband, farm, to supply the cattle feed and pig feed, my lord.
Yes.
And how much was the quantity, my lord? With reference to the subject cited above, I am to request you kindly supply the following quantities of cattle feeds and pig feeds to the different dispensary and aided center for the distribution as per list and close, and submit the bills for further necessary action. Now, my lord, serial number 1 is cattle feed 6,000 quintals and pig feed is 2,500 quintals, my lord. So we have supplied accordingly. A demand was made, my lord. We have supplied. Now, my lord, may kindly come to Annexure 3, my lord, page 36. The type copy, my lord, may kindly come directly to the type copy 37, page 37, my lord. Again, the district animal and husbandry veterinary officer, again he issued another order on 21st January 2015, my lord, where he said, my lord, again to supply 10,000 quintals of poultry feed, my lord. Accordingly, my lord, we have submitted our bill, that is on page 39.
Yes.
So the rate, my lord, which they have fixed, 35 rupees.
Yes.
According to that, my lord, the total bill was 2 crores 97 lakhs 50,000. It is the rate which has been fixed by them, my lord.
Yes.
If my lord may kindly come to page 42, Annexure 6.
Yes.
This is the letter, my lord, by which my bill has been forwarded by the District Animal and Husbandry and Veterinary Officer to the Deputy Commissioner Revenue, North Garo Hills, Resubelpara, my lord. With reference to the subject cited above, I have the honor to submit herewith the total amount of cattle, pig and poultry feed from so and so, that is my farm,
Yes.
has supplied to the flash flood affected families occurred on 21st and 22nd September 2014. The total amount is given below, my lord. So total amount, my lord, my claim is 6 crore 46 lakh 50,000 rupees, my lord. That much quantity of the requirement which was demand from me, my lord, I have supplied. Now, my lord, may kindly see Annexure 7, page 44.
Type copy.
Type copy is on page 46, my lord.
Refer to the type copy only.
Yes, my lord. That is dated 5/10/2021.
Yes.
And my lord, by this representation, we make a request to the District Animal and Husbandry Veterinary Officer to release our bill.
Yes.
My lord, may kindly see in reply to this letter, my lord, in page 50, the type copy is in page 51, on 26 October 2021.
Yes.
They have informed us, my lord,
Yes.
with reference to the subject cited above, I have the honor to inform you that the Office of the Undersigned is yet to receive the payment of the bill mentioned above from the Disaster and Revenue Department till date. The payment will be made as and when the amount is made available by the concerned department. Now, my lord, they are saying they are not raising any dispute about the quantity of feeds that we have supplied or the amount that we have asked for, more amount, my lord. They are not raising this issue, my lord. They are informing us that the money has not been sanctioned by the government, state government. For that reason, they are not in a position to pay us, my lord. And they have also assured us that whenever the money will be there, we'll pay you, my lord. They have not raised any dispute, my lord, on this. Now, my lord, may kindly see two affidavits which has been filed by the government.
Yes.
The first affidavit which was filed by the respondent number 1, he is the Commissioner Secretary Revenue and Disaster Management Department, Government of Meghalaya. Now, my lord, we kindly see page 5, my lord.
Yes.
Para 5 and 6. With regard to the averment made in para 5 and 6 of the writ petition, the answering deponent states not maintainable. Deponent states not maintainable. Respondent number 5, in the absence of the inquiry or assessment of the requirement amounts by the committee. The office could not have ordered for supply of 6,000 quintals of cattle feed, so and so, so and so, so and so. Hence, the amount quantity mentioned herein is unreasonable and appeared to be so and so, my lord. Now, my lord, the demand was made, and that is not the case of the district level committee, my lord, that we have not supplied. Now, state government cannot come from the department, my lord. They cannot come forward and they say that this amount is unimaginable amount. This much it is not required, or this much was not supplied, my lord. They have not even conducted an inquiry, as my learned senior has already pointed out. They are not making a statement on the basis of an evidence or a facts, my lord. Otherwise, they should have conducted an inquiry, and they have produced the inquiry report that, my lord, this is the inquiry and that this is the position. They have never supplied. They are not doing that, my lord. Now, another affidavit which was filed before this honorable court, my lord, in reply to our affidavit by the respondent number 3, my lord, who was handling the entire thing. Now, my lord, may kindly see para 19. As my learned senior has already read out, my lord, I'll just point out 2 or 3 things, my lord. My lord, may kindly see. Para 19, my lord, page 10.
Yes.
After inquiry, the district disaster management committee, white letter dated so and so, identified a petitioner. That means I am one of the petitioners, my lord, as one of the farm supplier who was in a position to make available the necessary stock pills of feed on short notice, my lord. That means on the short notice, my lord, we have supplied. Now, even though we have supplied, my lord, they are not releasing our bill. That is why we are before this honorable court. And my lord, there is a judgment of the honorable apex court which has held, my lord, that they are saying, my lord, on the last occasion, London AG has submitted that why not we go to the civil court, my lord. In Walpole, my lord, in Walpole case is a very famous case, my lord, where, my lord, the Supreme Court has held, my lord, alternative remedy is not a bar to entertain a writ petition under Article 226.
What is the citation?
Citation is, my lord, 1998, 8 SSC, para 1, my lord. Para?
Page
1, my lord.
Page 1, issue para 1?
No, sorry. Para 14 and 15, my lord.
Yes.
Even if there is an alternative remedy, my lord, the writ jurisdiction can be exercised.
Oh, that is
yes, my lord. Now, my lord, we kindly see, as my learned senior has clearly established, my lord, that we have supplied, demand was made. It is not that, my lord, we forcefully have supplied. They have made a request, my lord. Now, can they take a U-turn, my lord? That is also not by the district level, where, my lord, in the ground level who was there, and they have received the supply, my lord. Now, my lord, the state, because of some reason or the other, probably one of the reason may be because this order was issued during the previous government time.
This is all incorrect, my lord. There is no averment in the petition. He is making something which is the government comes and goes. Government comes and goes, but the decisions are binding. So you can't make those false allegations, my lord, without anything.
My lord,
we are all on YouTube. He is making allegations which are of political in nature.
You cannot infer.
My lord, I am making a submission, my lord. I may be wrong, my lord. That will not be entertained by this honorable court. I am just making a submission, my lord.
It has to be there in the pleading somewhere. It has to be there, not in the air, my lord. The pleading, you say something.
Even the affidavit has been filed by the state government, not after the inquiry, my lord.
Mr. Kumar, you are
going. I will demonstrate, my lord. Each and everything what he is saying is incorrect.
Your objection is noted, Mr. Kumar.
My lord,
and yeah, refrain. If it's no pleading in the
my lord may kindly appreciate why I have said this, my lord. Why I have said this. 3 farms was there, my lord. Now the unfortunate thing is this, my lord. 2 farm who are before this honorable court, their bills are not released. But a third firm, my lord, who was never before this honorable court, their bill has been released.
Leslie, how can he be before this court if he's...
No. What is my point is this, my lord. The people who comes with a clean hand, my lord, they are not entertained. But the people, my lord, who can manage, my lord, they have management to release the bill, my lord.
That's also an insinuation.
My lord, this is my point of understanding, my lord. My lord, there may be a different opinions on this, my lord, but this is my understanding, my lord. I may be wrong totally, my lord, but I'm just pointing out. 3 farms was entertained, my lord, or they was given the supply order. One was...
Yes, that point is valid.
My lord, how can it be correct, my lord? So my humble and respectful submission before this honorable court will be this, my lord, that even though there is an alternative remedy, my lord, writ jurisdiction can be exercised, my lord, and our prayer on the writ petition may be allowed, my lord. And we may be also permitted to reply after the learned AG places his case, my lord.
You are not relying on any authority except that one?
Yeah, except that one, my lord. Because learned senior has already relied on all the authorities, my lord.
So, Mr. Kumar, how soon can you reply?
Yes, Lord, may have it on Monday or Friday. This Friday also I can, my lord, I can.
Not on Friday.
Friday also I can.
Monday or permits. When it is still fresh, but it will be better.
Monday. So we'll have it on Monday then.
Yes, my lord.
Heard learned counsel for the petitioner. The learned AG has sought for some time to reply to the submission made. Accordingly, as agreed to by the parties, this is matter on 4th. That's Monday, isn't it? 4th.
Yes, ma'am.
For the hearing. So forth.